Good morning. Thank you all for being here at the University of Minnesota Psychiatry Department Grand Rounds. I'm Kaz Nelson. I'm the Vice Chair of Education. And again, it's my pleasure to introduce another one of our fourth-year psychiatry residents presenting their Grand Rounds presentation as a sort of a culmination of their career here at the University of Minnesota. And it's always a pleasure and an honor to do that, especially introducing Dr. Matt Kruse, who's been so productive and so active and so energetic and so skilled in our psychiatry residency. It's been a real joy to serve as his program director over this period of time. A little more about Matt. His BA is from Carleton College, where he majored in psychology. He attended the Yale School of Medicine for his medical degree and also completed his MBA at the Yale School of Management. He's had a variety of interests spanning his training, including interest in psychotic disorders, healthcare systems and policy, and forensic psychiatry. He's been involved with the Minnesota Psychiatric Society, including their legislative committee, and he's on the Minnesota Medical Society Policy Council and co-chair of the Twin Cities Medical Society Legislative Committee. In July, he'll be the first fellow in our newly accredited Forensics Fellowship, led by Dr. Chinmoy Gulrajani, who's been supervising him on this project of studying the evolving events of the Minnesota Sex Offender Program. And so without further ado, I'll turn things over to Dr. Cruz.
Thank you so much. All right, so I'm going to be talking about the Minnesota Sex Offender Program today. It's something that a few of you might have seen in the news recently. To begin, disclosure information. I have no financial relationships to disclose, and I will not discuss off-label use or investigational use in my presentation. Today I'm going to cover history of the sex offender commitment laws in Minnesota and in general in the United States. I'll highlight a few relevant events influencing the evolution of these commitment laws. I'll outline very briefly the legal basis for the constitutional commitment laws. And then finally, I'm going to examine a recent constitutional challenge to the Minnesota Sex Offender Program. Before I go on talking about Minnesota, I want to go back to Vienna, Shakespeare's Vienna, specifically in the setting for the play Measure for Measure. Vincentio, he's the Duke of Vienna, announces his departure and leaves the government in the hands of the judge Angelo. Angelo is very distraught at the unlawful sexual activity and loose morality that he sees in Vienna. He decides to enforce current laws in a much more strict manner. He soon arrests Claudio for fathering a child out of wedlock, in contrast with Vienna law, and sentences him to death. He ignores or is oblivious to the point that Claudio and Juliet were already engaged to be married before Juliet was impregnated. So Minnesota, 1939, 2 years after Michigan enacts their first sexual psychopathic law, Minnesota enacts its own psychopathic personality law in Minnesota. The aim of this law was to reduce the risk posed by individuals thought to be sexually dangerous. And the aim was really to divert certain people from prison and punishment into a treatment program. How long did it take for this law to be challenged in court? Between a few weeks and a few months. The Pearson challenge was really the first challenge to a sex offender commitment law and actually made its way all the way to the United States Supreme Court. Charles Edward Pearson was petitioned for commitment under the Minnesota Psychopathic Personality Law, and he opposed it on two constitutional fronts. One, he said that it violates due process and equal protection clauses, and in addition, he argued that the law, the language in the psychopathic personality law was too vague to be constitutional. I'm going to look a little bit closer at what these actually mean because it's going to be relevant for understanding some of the later case law. Due process is actually present in both the 5th and 14th Amendments of the Constitution, and it states in brief that any deprivation of civil liberties, whether it's life or liberty or property, if done by the state, has to be done with certain protections in place. This can include trials and access to a lawyer. The Supreme Court actually did not feel that these laws violated due process, and they said that this is a civil proceeding and not a criminal proceeding. The aim of these laws is for treatment and not punishment, and though you might have some protections, not all criminal protections apply, and this includes the due process. The Equal Protection Clause came about in the 14th Amendment after African Americans were subject to different legal standards than white counterparts, including stronger punishments. So Pearson argued that his status as a sex offender with a mental illness makes him more susceptible to legal restrictions than sex offenders without a mental illness and those with a mental illness who are not sex offenders. The Supreme Court actually disagreed with this argument as well, saying that it is not unconstitutional to recognize differing degrees of danger in individuals, and they stated that individuals who engage in certain sexual activity and are mentally ill do confer a higher level of danger. Finally, the last argument that I wanted to highlight, whether the psychopathic personality law was too vague. The Supreme Court actually rejected this as well. They said that the law actually serves its purpose, although they did admit that the wording could be a little bit better. The way that the law originally worded it was they outlined psychopathic personality as the existence in any person of such conditions of emotional instability or impulsiveness of behavior or lack of customary standards of good judgment or failure to appreciate the consequences of his acts, or a combination of any such conditions as to render such person irresponsible for his conduct with respect to sexual matters and thereby dangerous to other persons. I agree, the wording may be a little long. So they initiated a three-pronged test, later known as the Pearson standard. They said a better definition would be anyone that engages in a habitual course of misconduct in sexual matters as evidenced by an utter lack of power to control their sexual impulses. As a result, they are likely to attack or inflict injury, loss, pain, or other evil on objects of their uncontrolled and uncontrollable desire. So, over the course of 1940 and 1960, the Pearson ruling really cleared the way for similar psychopath laws to be enacted across the country. I highlighted the states in blue that by 1960 had sexual psychopath laws. This included 25 states and Washington, D.C. Again, the aim was diversion of some offenders from prison and typically included first-time offenders, those arrested for voyeurism, and even homosexual men engaging in consensual relationships. Those that were committed under this first generation of laws were typically released within about a year, and violent repeat offenders were typically incarcerated and not typically subject to these laws. Meanwhile, in the 1970s and 80s, we actually found the opposite trend. A lot of these statutes were actually challenged in court and repealed, and this was due to a couple of things. There was growing skepticism about whether the treatments afforded in these laws were actually effective. Additionally, there was another skepticism about how well we could actually predict future dangerousness. And with ongoing constitutional challenges in courts and waning public support, ultimately this led to repeal in a majority of these states. Nevertheless, over the period of these waning statutes, there were plenty of constitutional challenges, and the Supreme Court heard many of them. Over this time, the Supreme Court did actually act to find an optimal balance between personal liberty and public interest. And during this time, they made several decisions that actually limited the state's ability to commit people under sexual psychopathic laws. On the other hand, the chipping away at some of these states' powers did stop at a notable case, and this was Allen versus Illinois, and this occurred in 1986. Terry Allen was charged with unlawful restraint and deviant sexual assault in the state of Illinois. He was incarcerated after conviction, and prior to his release from prison, they pursued commitment and confinement under the state's Sexually Dangerous Persons Act. Mr. Allen was interviewed by 2 psychiatrists, and based on the psychiatric testimony, he was found to be a sexually dangerous person and committed and confined under this act. He opposed this on constitutional grounds, and it went all the way to the Supreme Court. What he was arguing is his protection against self-incrimination was blocked. So freedom from self-incrimination says that in a criminal proceeding, you shouldn't have to answer questions that might incriminate you. And he said by having to undergo psychiatric evaluation, he was basically incriminating himself. The Supreme Court actually did not agree with this argument. Like the Pearson case, they said that this is a civil commitment and not a criminal proceeding. The idea is we want to get you into treatment and not to punish you. And for that reason, while you might have some liberties afforded to you similar to criminal proceedings, this is not one of them. And psychiatric testimony is not relevant here. Nevertheless, this doesn't mean that this was a really clear way forward for sex offender commitment laws. The Supreme decision was actually split 5-4, and there was a very strong dissent. Justice Stevens was among the dissenters, and he stressed that the power of the state commitment laws were very, very high, and in some cases, even though they were not criminal, should not be discounted as an incredible power. And this dissent in Allen versus Illinois really did hint at future constitutional challenges for these laws. So we're back to Minnesota in 1988. At this point, Minnesota is one of the states that has still retained their sexual psychopathic laws. At this point, it was actually in generally limited use. But in 1988, there were several highly publicized rape and murders in the Twin Cities areas. In all of these cases, the perpetrators had a history of repeated sexual assault, and in these cases, the perpetrators had recently been released from prison. In the case of the murder of Mary Foley, the perpetrator had been released from prison just 26 days earlier. This caused a huge public backlash, and in response, the Attorney General ordered a task force to examine sexual violence against women in the state. Based on the task force recommendation, the 1989 Minnesota legislature took action. They decided they wanted to more easily identify potentially dangerous offenders, and courts were encouraged to consider psychopathic personality commitment at the time of initial sentencing. They also increased the maximum sentences for criminal sexual conduct, and Minnesota actually passed the pattern sex offender statute, which allowed for longer sentences for those considered to be more likely to offend. Even more highly publicized sexual assaults and murders happened in approximately 1990, further toughening sentencing in the state. And the Minnesota Commissioner of Corrections began systematically evaluating sex offenders prior to release from prison and referring them to county attorneys for commitment. So what was the effect of this? So in the entire decade of the 1970s, there were approximately 13 individuals committed under the sexual psychopath laws. In the 1980s, there were 14. There were actually 2 in the year of 1990, but in the span of 1990 to 1995, there were 100 individuals that were referred and committed under these laws. The stark increase in the referrals for commitment was actually what spurred the government to actually allocate money to found a new treatment program for these individuals at Moose Lake. So far, all the commitments we've talked about were under the original sexual psychopathic personality statute and the standard established in the Pearson case. Dennis Lenihan was arrested in 1970s for kidnapping and murder of a 14-year-old girl. He pled guilty to kidnapping, and as a result, the murder charge was dropped. His record contained long history of sexual assault and attempted sexual assault beginning in his teenage years. As his 1992 release date approached, Ramsey County petitioned for commitment under the psychopathic personality statute. The courts agreed that he met criteria for psychopathic personality and ordered indefinite commitment to the Minnesota Security Hospital. Lenihan appealed the commitment, arguing that the state failed to establish the Pearson standard as outlined in the sexual psychopathic law. The Minnesota Supreme Court agreed and noted that an utter lack of power to control sexual impulses is incredibly hard to demonstrate, even with expert testimony. Now, talking about an utter lack of power, this is somewhat analogous to what criminal proceedings will talk about, an irresistible impulse test, which is to say, even if Lenihan had a police officer standing at his elbow, he would be so out of control that he would still commit a sexual assault and not even wait for the police officer to leave the room. In 1994, the court agreed and Lenihan's commitment was vacated. So he now became a parolee. There was nowhere in the state that would really accept his placement, so he was placed in a converted halfway house right on the grounds of the Stillwater Correctional Facility. The halfway house is fitted with phone taps, video surveillance, regular drug testing, and in addition, ongoing sex offender treatment. This, like many of the other events I talked about, was met by quite a bit of public backlash. And the inability to commit Lenihan under the current laws was a huge blow to the state. On August 31st, 1994, the governor called a special legislative session. The aim was to increase the prosecutor's power to commit and confine sex offenders. This established a new category for commitment, the sexually dangerous persons. You might notice that the criteria for this is a little bit different from the sexual psychopathic. It merely outlines that someone needs to have engaged in a course of harmful sexual conduct, has manifested sexual, personality, or other mental disorder or dysfunction, and as a result is likely to engage in acts of harmful sexual conduct. This new bill was introduced, passed, and signed into law on August 31st, 1994, and took effect on September 1st, 1994. As a result, Lenihan actually met criteria for this new statute and was committed as a sexually dangerous person. This is really in the setting of really a resurgence of a new family of commitment statutes. Although they had diminished over the 70s and 80s, the implementation of the dangerous person statute in Minnesota was just one of several new programs. In almost all cases, these laws were passed in the setting of a very publicized murder. So for instance, in 1990, the Community Protection Act was in response to the murder by Earl Kenneth Schreiner. And then in 1994, the Sexually Violent Predator Act was enacted after the murder by Donald Ray Gideon. In virtually all of these cases, the constitutionality of each act was challenged. The challenge to this Kansas Sexually Violent Predator Act in 1997 was one of the more important Supreme Court cases that established what a constitutional commitment law actually looks like. Leroy Hendricks was convicted of molestation of 2 teenage boys and incarcerated. He had an incredibly extensive history of multiple convictions for similar offenses. As his release date approached, Kansas sought to commit and confine him as a sexually violent predator. He expressed hope that he would be able to break his pattern of sexual activity, but noted that the only way he could guarantee such a thing was to die. He did not disagree with the expert diagnosis of pedophilia, and he admitted to his ongoing urges and expressed concern that treatment would not likely be effective for him. He nevertheless appealed his commitment status to under the statute. His argument was a couple of fold. He argued that a finding of a mental abnormality is not the same as the finding of a mental illness and does not satisfy the constitutional requirements for commitment and treatment. The Supreme Court disagreed. They noted that psychiatrists often disagree widely about what constitutes a mental illness, and they agreed that pedophilia was enough to establish an appropriate mental abnormality, and the use of the term mental abnormality in this law was constitutional and appropriate. Hendricks also argued that there is no effective treatment, but the Supreme Court says that whether or not there's effective treatment is irrelevant to your commitment. Finally, he argued on constitutional grounds that being committed at the end of his prison sentence violated several criminal protections, including ex post facto and double jeopardy. As we saw in a lot of the previous rulings, the Supreme Court came back and said, no, the purpose of this statute is treatment. It is not to punish you. It is not to incarcerate you. It is to treat you, and criminal protections do not uniformly apply. Minnesota is also not immune to the public outcry and call for action in response to heinous crimes. Drew Shadeen was a 22-year-old college student from Minnesota. She was abducted from the Columbia Mall parking lot in Grand Forks, North Dakota on November 22, 2003. A week later, Alfonso Rodriguez Jr., a 50-year-old level 3 sex offender, was arrested in connection with her disappearance. Shadeen's body was later discovered near Crookston, Minnesota, and Rodriguez was convicted for her murder and sentenced to death. In response to the Drew Shadeen case, there was a lot of outcry about it. Rodriguez's status as a sex offender really was prominent on both a local and national scale. Drew's Law was passed in 2006 and signed into law by George W. Bush. It set up the Drew Shadeen National Sex Offender Public Registry. It also influenced the use of the sexually dangerous and sexual psychopathic laws here in Minnesota. Prior to 2003, the Department of Corrections focused on identifying only the most dangerous offenders that might be fitting for commitment as their parole date approached. But starting in December 2003, approximately 1 week after the murder of Shadeen, all sex offenders who Department of Corrections believed may satisfy the legal commitment standards were referred to county attorneys for civil commitment. So what effect did this have on our laws and our commitment? From 2001 to 2003, there were approximately 333 referrals for commitment. In the month of December 2003 alone, there were 236 referrals. We've even plotted them out here by time, and you can see right here, December is when the DLC referrals really spiked. Thereafter, on average, the Department of Corrections referred approximately 157 individuals for commitment per year. The aftermath of the Drew Shadeen case really set the stage for the current state of the Minnesota sex offender program. So where are we currently? Over the past decade, the Minnesota sex offender program has been reviewed by the legislative auditor on multiple occasions. As of 2010, Minnesota has had by far the highest number of civilly committed sex offenders per million residents. We have approximately 110 committed per million residents. Compared to other states with similar commitment statutes, their average is 27. The absolute number of those committed currently is over 700. Since the modern status of the sex offender program, although we have over 700 committed, since 1994, we have had 3 provisional discharges and 0 full discharges. Wisconsin is a state with a similar statute and a similar demographic. In that same time, of course, they have had 118 full discharges and 135 offenders on supervised release. What facilities do we have with the Minnesota Sex Offender Program? We have a secure treatment facility at Moose Lake. We have a secure facility at St. Peter. And we have a community preparation services facility, which is of lower security, but is also at St. Peter and is outside the secure perimeter. At the CPS facility, there is still GPS monitoring for each committee, and they are subject to regular room searches and drug testing. Notably, there are no less restrictive alternatives for anybody committed to the Minnesota Sex Offender Program. This is a view inside the treatment facility at Moose Lake. What is the process for commitment? It is initiated by county attorneys, but these are facilitated by referrals from the Department of Corrections. Offenders are guaranteed access to a lawyer to fight against the commitment in an adversarial hearing, and they can only be committed based on a clear and convincing evidential standard. The constitutionality of the Minnesota Sex Offender Program was questioned in a class action lawsuit brought in 2011 against the Department of Human Services. Really, at the core of this case are 2 big questions. One, does the Minnesota Sex Offender Program provide treatment, or does it provide punishment? And again, does the Minnesota Sex Offender Program uphold standards for civil commitment? So first, let's examine the treatment at the Minnesota Sex Offender Program. As of 2008, the treatment progresses in 3 phases. The phase 1 aims at compliance of rules and treatment alliance. In phase 2, there's exploration of previous patterns of sexual behaviors. And then finally, in stage 3, they work on reintegration into society, including discharge planning and strategies for moving on with one's life. Each time that the clinical leadership has changed in the past, the organization of the treatment has changed. So before 2008, under a different clinical director, they were different phases. Although the aim of treatment is to allow individuals to reintegrate into society, these services presented in Phase 3 are only available to those that have progressed to Phase 3. Any individual in Phase 1 or Phase 2 of treatment is not allowed assistance in discharge planning or reintegration skills into society. Again, although individuals may theoretically start at any phase when they are admitted to the Minnesota Sex Offender Program, virtually all new admissions start at Phase 1. This is outside records are not routinely obtained upon arrival at the Minnesota Sex Offender Program, and previous sex offender treatment, even completion of sex offender treatment in the past, is not considered when placed into phase of treatment. I would also note that progression through the phases is quite onerous. Here are the criteria for progression from Phase 1 to Phase 2. All progression in the phases is based on a completion of matrix factors that are filled out by the counselors at the Minnesota Sex Offender Program. So this alone is the criteria from Phase 1 to Phase 2. I would note that there are a lot of barriers to progression. This looks a little complicated, but it can actually even be more complex. There are quite a few barriers to treatment progression that I really want to highlight. The matrices are not used by any other commitment program in the country. Scoring is actually quite inconsistent. Scores can actually fluctuate wildly depending on which counselor is actually filling them out. Newer staff often provide lower scores on the matrices, and there is actually quite high turnover at the Minnesota Sex Offender Program. Behavioral expectation reports are unduly strict. Whenever anybody engages in behavior that is not becoming of the Minnesota Sex Offender Program, it's turned into a report. Larger BERs can send an individual to a lower phase of treatment. Even minor incidents can prevent phase progression, even if the BER is completely unrelated to sex offending. There was one incident in which a patient was moved from Phase 2 of treatment to Phase 1 of treatment because he was in possession of adult legal pornography. The difficulty in progression has really led to an environment of hopelessness among the MSOP population. And often they feel that it is hopeless to engage in care, and then they elect eventually not to. In 2012, the MSOP timeline suggested approximately 6 to 9 years to complete all 3 phases of treatment for a model client. But there is no set timeline for completion. There are some individuals at the Minnesota Sex Offender Program that have been in this treatment regimen for greater than 20 years. In addition, there's no individualization for goals and expectations of the treatment. They use identical matrix factors for individuals with severe mental illness, cognitive disabilities, vulnerable adults with assisted living needs, individuals with severe behavioral issues, and juvenile-only offenders. Next, the question is whether the Minnesota Sex Offender Program upholds the generally accepted standards for commitment. I would first point out that after the initial risk assessment that leads to their commitment to MSOP, there is no mandated repeat risk assessment after the initial commitment. I would highlight at this point that potentially indefinite commitment is not the same as indefinite commitment. In other states, risk assessments are done on an annual basis to make sure that requirement for commitment is still met. If that standard is not met, the person is no longer in the program. Yes, this can potentially lead to indefinite commitment if they continually fail to meet criteria for discharge. But in this case, if they meet initial criteria for commitment, it is an indefinite commitment because in lieu of any action thereafter, they will remain committed. There is no data collected at MSOP on a regular basis to establish the need for ongoing commitment, treatment, or whether they actually still provide a danger to public. Furthermore, in testimony at the Carson's case, the MSOP admits that they do not have a standardized method for conducting risk assessments, and several MSOP risk assessors testified in court stating that they did not receive any formal legal training regarding risk assessment and admitted to not knowing the constitutional standards for ongoing commitment. So someone at MSOP says, I don't really qualify for commitment and I want a petition for my release. So what does that process look like? A petition can be made by the committed individual, the executive director, or the executive director greater than 6 months after either the initial commitment or prior petition. Notably, in other states with similar laws, a petition can be made at absolutely any time. A recommendation is made by a special review board to the Supreme Court appeal panel, which makes the final decision. The provisional and full discharge criteria are based on ongoing danger, ongoing need for treatment, danger to the public, and so forth. They found in the class action lawsuit that the provisional and full discharge criteria are much harder to prove in court than the initial commitment criteria. Furthermore, the Special Review Board frequently will listen to the recommendations of the Minnesota Sex Offender Program when determining its decision. In very rare cases has the Special Review Board ever gone against the recommendations of MSOP. Furthermore, the MSOP has virtually never supported a reduction in custody or full discharge of anybody that has not completed full 3 phases of the MSOP treatment system. So in a sense, what is happening is discharge is indirectly tied to program completion rather than ongoing dangerousness or ongoing criteria for commitment. I would also point out that there is no time restriction for the Supreme Court appeal panel to make its decision. In some cases, people have petitioned and waited years for the decision. So what happened at the end of the class action lawsuit? In June 2015, the MSOP was ruled unconstitutional by a federal judge. In that ruling, he made several orders. He ordered evaluations of all approximately 720 sex offenders housed at Moose Lake and St. Peter. He mandated the release of those who no longer meet requirements for confinement, and he also urged the establishment of less restrictive treatment options. The state immediately appealed, and the court order was placed on a hold. So what has happened since then? April 12, 2016, otherwise known as yesterday, the appeals court in St. Louis heard a challenge to the constitutionality of the Minnesota Sex Offender Program. Oral arguments began yesterday, and they are continuing today. Among the arguments, the state is alleging that the federal judge had made up his mind before the trial, but we will see what the outcome of that argument is. What's happening outside of the courts? If anybody is reading the Star Tribune, you will see a lot of headlines about the impending release of sex offenders. There are a lot of town hall events and a lot of laws being passed to restrict the ability of released sex offenders, regardless of dangerousness, from moving into their communities. So what is the important takeaway from this story? First, the Minnesota Sex Offender Program has been operating with no proper oversight and observations of commitment and care based on the court decision. There's been a lack of adequate involvement from physicians and psychiatrists, even though this is one of the largest commitment and treatment programs available in the state. Psychiatrists really need to be involved on a policy level and a treatment level. And what are the reasons for this? I would really point out that sex offenses really evoke strong emotions and is very politically charged. Mandating the release of sex offenders is not an easy thing to do, even if it is mandated and constitutional. I think psychiatrists have an ability to maintain a bird's eye view, come at this issue with evidence and data and expertise, and not be as reactionary as the public may be. Additionally, sex offender laws are additionally often enforced without necessary distinction and stratification. The Adam Walsh Act requires sex offender registration for children as young as 14. Human Rights Watch has had reports on a 10-year-old who was adjudicated for inappropriately touching his 5-year-old cousin and now must register for life as a sex offender. In some areas, even public urination may lead to status as a sex offender. Ultimately, ongoing alienation and strong enforcement of laws without any nuance to this stratification may ultimately pose a paradoxical risk to society. We as psychiatrists must step up to better understand these actions, why they occur, and how to better understand and treat them. We can and should influence policy and treatment to protect both public and individual interests. Meanwhile, back in Shakespeare's Vienna, I can't help but be reminded of the warnings that Shakespeare presents in Measure for Measure. In the final act, we learn that the Duke has been hiding in Vienna during Antonio's reign in disguise the entire time. The Duke hears the grievances against Angelo during his time undercover, and Angelo confesses to his shortcomings. Claudio is pardoned for his sex offense and is allowed to go free. Today, we began to explore a difficult issue that may lead to a slippery and vague moral dichotomy. In Act 2, Scene 1 of Measure for Measure, Aeschylus states, "Well, heaven forgive him, and forgive us all. Some rise by sin, and some by virtue fall. Some run from breaks of ice and answer none, and some condemned for a fault alone." I'd like to make an especial thanks to Chinmoy Gorajani for mentorship and guidance in preparing today's Grand Rounds, and I'd like to leave plenty of time for discussion and questions. Thank you.
Thank you. Questions? Comments?
I have to gather my thoughts. So I worked with a lot of victims of sexual assault as an OBGYN. So it's hard for me to hear, this talk. I'm also, belong to the ACLU, so
absolutely.
It's a very black and white issue for me, and so a couple questions are, it'd be interesting to have see in all these other states besides Minnesota where people are released, the perpetrators are released, is how many reoffend? What's their reoffending rate?
Right.
Because ours probably won't reoffend because they never leave. And what's the other question? I was going to my blank. This is a tough topic.
It is.
Why is it civil and not criminal?
Why is what?
Why are sex offenses a civil issue and not a criminal issue?
So that's a really good question. So these are still criminal issues. When I'm talking about people that are committed to MSOP, really the population I'm talking about are people who are convicted of a sex offense and are sent to prison. They complete their prison sentences. In lieu of these laws, these people would naturally, without any other concern, be released at the end of their prison sentences. One of the reasons these laws are constitutionally challenged is what these laws do is instead of being released at the end of their court-mandated prison sentence, are no longer released to society, but in fact continually confined for some, in many cases, indefinite length thereafter. So the civil component of this is really separate from the criminal part, and that's a good point. The criminal portion is still there. Did that answer your question, or? Okay.
Matt, could you give us some idea of what constitutes treatment for these sexual offenders?
Yeah.
I assume if they have underlying psychiatric disorder, one would treat that. But specifically for pedophilia or any of these other offenses, what do they do?
That's a really good question, and there are no, silver bullet treatments. Really, one of the mainstays of treatment continues to be cognitive behavioral therapy. But I think an important thing to keep in mind is something that I alluded to at the end of the talk is these are very heterogeneous. So, for instance, if you have two people convicted under the guise of pedophilia, one of them may be a contact offense, and if you look at the offense, it was really a function of opportunity. They may have been under the influence of substances, and they kind of lost control of themselves, but may at heart have no attraction to children. Meanwhile, someone else that views child pornography on a regular basis is actually going to be more likely to have true pedophilia. Meanwhile, under the law, there is no distinction there, and treatments are likely going to be similar. And I think that opens the gateway for psychiatrists and the other mental health community to understand what is driving this action and what's going to constitute better treatment. Those are used in some cases. I don't know the rate at which they're used. Dr. Olson asked if androgens are used as a form of chemical castration. Yep. And I know that they are used in some cases, but I don't know what the legal standards, especially if it's used against their will. Dr. Goljani, do you know?
I don't know about Minnesota, but in several other states, anti-androgens are used in coercion, or what is considered coercion by psychiatrists. So essentially, the person who's committed is told you will be allowed off grounds if you continue to take estrogen injections for the next several months. So there's implied consent, but then also they're being forced to take that treatment in exchange for liberty. Just to answer that. I actually had a comment. Thank you. This is a wonderful presentation, Matt.
Thank you.
I wanted to speak to the lady, the first question posed. This is a very difficult issue with widespread and profound social implications and social reactions. One of the things that also I wanted to highlight was that Minnesota spends a lot of money in the Minnesota sex offender program. It is one of the costliest programs administered by the state, right? And the idea behind the lawsuit was that one size does not fit all. There are definitely individuals who deserve to be committed indefinitely for life because they have proven that they're habitually dangerous. But then there's also another spectrum of individuals who are in for minor offenses like public urination and masturbation and have no really good track record. Unfortunately, the statutes are so broad and wide is that everybody gets clumped in the same group. So a person who is a pedophile compared to any other individual who has committed childhood sexual abuse is considered equal, while clinically they are not. And the reason that they are is because we're not involved enough. Thank you.
So one of the reasons that we're not involved so much is because it was felt that since people in this program never get out, what the psychiatrist is doing is presiding over indefinite confinement. And it was a sham that I would be there or a psychiatrist would be there providing treatment when there was really no outcome that would allow discharge. And so before you got here, this was the attitude of the psychiatry profession about their participation in the sex offender program. So the question I have then, because the Supreme Court said you could be confined even if there was no treatment. So one of our psychiatrists, Dr. Farnsworth, developed a sex offender program way back. And then once you say there's a treatment, then you have to have a process and response to treatment. Maybe that was the mistake in the first place, that we said there was a treatment. Had there not been a treatment, they could have been confined forever.
Well, there are other issues. And I'll come back to you. I'm sorry, I know, but this is just... There are other issues. Dangerousness is not always linked to response to treatment. You know, a 15-year-old or a 20-year-old is more dangerous to a 75-year-old. Under these laws, a 20-year-old and a 75-year-old are considered equally dangerous, and they're locked away and the key is thrown. Right? The other big issue that I want to point out here in this audience is all the diagnoses are made on the basis of the DSM-5. The profession of psychiatry is still being used for these commitments, for these purposes, with the involvement of no psychiatrists. Sex offenders have the status of leprosy in our community. Nobody wants to go near them. Nobody wants to talk about it. Why? They're sex offenders, let's lock them and throw the key away. Right? But how are we going to get into these conversations in the first place if you don't even talk, if you're not even willing to talk about them? So, and I'm going to stop.
Yeah, well, my question is about the criminalization versus the commitment idea. Mm-hmm. It seems to me, of the psychiatrists I know, that they do not particularly have more equanimity and more ability to predict dangerousness than anyone else. And I think the mistake is to say this is a matter of mental illness. I think that the people that make the laws and enforce the laws should listen to psychiatrists. We have a lot of helpful things we could tell them. But I think we should get out of trying to protect society. That is not the job of psychiatrists. That's the job of the law. Why isn't there like criminal penalties that would keep people that really are dangerous locked up? What does that have to do with commitment?
So that's a really good question. I agree that on its face, yes, protecting society is not our profession. On the other hand, if you look at the statutes, to even qualify for commitment, you have to be suffering from a mental illness. I am not arguing that all sex offenders are mentally ill, or that sex offense is a mental health issue. Nevertheless, this is a mechanism by which we've identified people where mental illness may be influencing behavior. And I think that the job of psychiatry is, on one hand, really to protect the mentally ill.
Hey, Matt.
Hi.
Thanks for doing this topic. It was really interesting. So prior to coming to medical school, I was working with teenage boys, many whom had sex offenses. And I really appreciated that you kind of highlighted the need for stratification, because I definitely saw a variety. And one thing that I think is interesting that's happening nationally, I don't know if it's happened here in Minnesota, is that with like sexting becoming really popular and teenagers sending like explicit photos of one another, there's actually been teenagers that are charged and are made to register as sex offenders for receiving like a consensual like naked photo of their girlfriend, and they're being charged with child pornography, which is clearly different than somebody who is. Or
the person that takes the picture is charged with producing and disseminating across state lines in some cases.
So I think that's an interesting thing, and also thinking about technology and how we're probably kind of behind on that front as well.
Yeah. And that's why we have laws, but I think we also need to rely on expertise to understand, what it is that we're really identifying and doing with our laws.
Do you have any information about how Western European nations handle this problem?
That is a good question, and I actually don't. But I know someone that might.
Again, I have two comments. Treatment of behavioral health has undergone changes within this century. The paradigm used to be need for treatment. Now the paradigm at every setting is dangerousness. It's not just commitment of sex offenders. It's any civil commitment requires two conditions: dangerousness and a mental disorder. This is not an issue pertaining to sex offenders. I don't think it's a fair statement to say that we should not be in the business of protecting people, because we are in that business. We cannot wash our hands off of it so easily. People are only admitted and medicated or treated against their will when they're found to be dangerous to themselves or others. Right, they're not sexually dangerous in all scenarios, but these people are in the same boat. Scandinavian nations have done a great job. They are, Minnesota in all other spheres are is generally a low incarceration rate, except for this one. And if you look at models from Scandinavia, several sex offenders and even serious sex offenders are allowed liberty. They're allowed to stay in the society as long as they are able to follow with probationary supervision and the conditions that come with it. So just to answer your question, not every society or every culture is as punitive as ours is.
All right, and we'll just do one more question here.
I had a question about, so there's a debate of whether psychiatry should be involved or not be involved. But as the program exists right now, assuming it doesn't just completely get wiped out, like, who is currently responsible for the creation, upkeep of like the matrix that you referred to, and sort of the logistics of the program, and where are these criteria coming from? How are they made? And where would there be, I guess, sort of from that point, where is the place to insert medical, like a more scientific-based approach?
So that's a great question. So again, the program is under the purview of the Department of Human Services. The treatment is typically, there is a clinical director that oversees the therapeutic component of MSOP. In terms of how to introduce the medical model into this, again, I think advocating, lending our expertise, really making sure that we, are vocal about the ongoing commitment statutes, how to commit a mentally ill person legally, constitutionally, in a way that protects their own agency as much as possible. And I guess the question is, Dr. Ryomuto said, we thought that it was not ethical, so we washed our hands of it. Well, it's almost akin to not liking an administration and moving to Canada. I would argue that that's probably the wrong approach. Probably the right approach is to be more politically involved.
Thank you all for the discussion, and thank you, Dr. Cruz, for the great presentation.
Thank you.
You have been disconnected.